got it. So this morning we had a conference in Chambers. As you folks know, there's two pending motions now. There is a motion for a Frye hearing. We received, and a Frye hearing is really the admissibility of this new, what they call science. We call it magic, quite frankly. We can get into that a little further. They have submitted what is called an affirmation in opposition. I have not had the opportunity to read it, but what I've been told is, in essence, they are consenting to an actual Frye hearing. So we can sit in a courtroom and actually have the judge determine if this is in fact science, if this is acceptable within the scientific community, and if it should come into trial. We obviously feel that it should not, and it's not science. So that's one issue. The second motion that we have pending is a motion to sever, and we have filed a motion to separate from the initial four, I'm not going to say counts, but the initial four victims from the other three that came forth in the superseding indictments. Because it's our position that it should not be cumulative, it should not be tried together, but rather the four initial, what they call the four victims, should be tried on their own, and then subsequent to that, we can go forward on the next matters. So those are the two motions that are pending. The judge put the case over till February 18th. Now what's important is this morning we filed on the prosecutor a demand. Quite frankly, we shouldn't have to demand these items, but we did file a demand. And this demand is in essence 14 paragraphs. I'm going to file the demand with special term when I'm done speaking to you folks. And also I'm going to have Grant Parpin have a copy of it, and you can reach out to Newsday. He loves when he sits at his desk for the next 5 hours and disseminates it. So he'll have a copy as well. This demand is really about the testing that was done here in this lab out on the West Coast. And we have maintained that we have not received a lot of this information, and we need that information, number one, to have for our experts and to go forward with the Frye hearing. What became obvious to us during the course of our discovery review is this Astrea, and it's Dr. Green, they outsourced a lot of their testing. And we want those documents and lab notes from the outsourced labs that in essence then turned over those results, gave it to Dr. Green, and then he did his magic on the West Coast. So that's what we're looking forward to getting. The judge put it over till February 18th to give Mr. Tierney and myself the opportunity to discuss what if any of our requests will be complied with, what they feel is inappropriate, and then we can have a subsequent discussion with the judge on February 18th. So that's where we're at. I'm happy to answer any questions.
Mike, are you looking for one trial with 4 and then 3 separate trials, if you could look that way, or one trial with 4 and then another trial with the other 3? I apologize.
Yeah, so the initial, the severance motion is to sever or separate the first 4 from the next 3, and the next 3 would be single trials if we had our way.
Can you talk about why you're referring to the DNA technology as magic?
I can. Dr. Green is not a DNA expert. This is a company that was formed on the West Coast. They are not, let's start off with the basics. They're not an accredited New York State lab. In New York State, and you folks can look at it, it's called the public health law. You have to be an accredited lab in New York State to offer into court, or to even get over that hurdle, evidence or testing results that you have done. Astrea is not an accredited New York State lab. That's the first part. The second part of it is, what they do is he's created this, and keep in mind, our state has never accepted Dr. Green's science. Thus we're having, or want to have, this Frye hearing. I don't know of any state in the union that has accepted in their courtroom on a criminal case Dr. Green's testing, with the exception of the state of Idaho. And there was a murder case where Dr. Green testified to, and my belief, and I think Ms. Koish can address this more eloquently, I don't believe that there was an actual Frye hearing in the state of Idaho. Am I correct in saying that?
Yeah, the state of Idaho specifically rejects both Frye and Dalbert, so it's never been the subject of any sort of judicial testing or any standard. So this is the first time in the United States that it will be done.
So that's another part of this. Dr. Green's lab is let's call it what it is. It's a for-profit lab. I've seen the bills that they have billed the Suffolk County District Attorney's Office for the work that they've done. And again, I'm not suggesting people should work for free, but if you look at the amount of money that this lab has generated and billed as a result of their testing, this enriches people. And their bills are $50,000, $60,000, $40,000 when they test these hairs. And there's a lot of bills in the discovery. Dr. Green has this computer program, and my experts have looked at his computer program. And Dr. Green will come out in his statistics and tell you that the chances of a similar situated profile would be a number that we can't even fathom, 1 in a quadrillion. My experts say it's more of the mitochondrial at best, which would be 1 in 10,000 at best. That's a huge disparity. That's a game changer. If it's 1 in a quadrillion, that's a very, very difficult number to fathom. If it's 1 in 1,000 or 1 in 10,000, that is less than convincing. That doesn't really say much. That says that there are thousands and thousands of potential donors for that profile just here in Suffolk County and Long Island. So it's an important point. And going back to your question about the magic, it has not been accepted anywhere under a Frye standard. This is a for-profit company. This is somebody who has yet to be challenged or tested in any courtroom on a criminal level. And my experts have indicated to me, and my experts are very well qualified, they have indicated to me that this is magic. So that's why I use that word.
Thank you.
Anybody else?
Why do you want the cases severed?
Because what happens when as a prosecutor, the government wants to put as much into an indictment as possible. There's this old adage that says when there's smoke, there's fire. So when you have count after count, charge after charge, it leads a jury, despite a judge's instruction, it leads a jury to say, you know what, there's so much there. He may not be guilty of this, but maybe he's guilty of that. And it's what we call a cumulative effect. Each case has to be proved with the elements beyond a reasonable doubt. That's the law, that's the requirement, and that's what the judge will tell the jury. The danger of having count after count, victim after victim in the same trial is that smoke, there's fire mentality. They shouldn't be tried together. One issue has nothing to do with the other. Now, conceitedly, the Gilgo 4, the first 4 young ladies that were victims from the Gilgo dumping ground, those are similar in nature. They're all the same. There's reasons why you would have them tried together. Judicial economy. It's the same witnesses are going to come in. It's the same evidence that will be presented. It's the same type of murder that was allegedly committed. That is far and apart from Ms. Mack, Ms. Taylor, Ms. Castillo. Those are far removed in terms of time frames. They're far removed in terms of location. They're far removed in terms of how the murders allegedly were committed. There's so many differences from those 3, and those 3 also in some respects are different from each other. So the answer is they should be tried separately so that there's no prejudice to the defendant. And he can get a fair trial. That's what it's all about.
Mike, just
Sorry, you're saying that
the motion states that 7 through 10 should be separated from 1 through 6, right? So isn't it the first 3 that you guys are asking to be separate from the other 4?
So the first 3 that were indicted together, we moved to, or we agreed that those 3 should be tried together. The 4th, I think it was
Maureen.
Brandon Barnes.
we said should be severed from the first 3, and then 6 and 7 should also be severed.
I misspoke, and I misspoke because it's a very, very, very well-written motion, and Ms. Koish did it all. I had nothing to do with it, so, yes.
So can you rephrase what you're asking? You're asking for the first 3, then
So we have,
you can look that
that's
straight up.
okay.
Thank you.
So we have 7 victims, right? They span in time over 20 years. We have the Gilgo 4, which you guys have named them. Of those 3, those first 3 are tied together, right? And then we have Maureen, who is the 4th. And then we have other bodies that were found out east in a completely dissimilar manner than the Gilgo 4, right? So it's to us a no-brainer that those should be excluded, both in time, in appearance, in witnesses and everything. So we moved, the DA is gonna wanna keep those Gilgo 4 together, right? Because they were found in the same place, similar manner, similar crime scene. But we moved to separate Maureen from those first 3. In terms of evidence and things like that, and that's what we did, and it's up to the judge to decide.
Wait, so you're looking for altogether 1, 2, 3, 4, 5 separate trials, or am I wrong then? Cause the 3 separate, you want 3 separate?
So what happens is for the first 3, Mr. Heuermann is charged what we call the serial killer statute, right? If you commit 3 murders within a certain time period, they could be charged with the A1 murder, right? So those first 3 bodies fit within the time frame for that A1. So those 3 theoretically should be kept together because the timing of the deaths are important. Maureen falls outside the time frame. That's why there's no murder 1 charge associated with her. And then we have the victims that were found out east in a completely dissimilar way. You know, you have this idea that there's this murder that happens and bodies are wrapped up in burlap and put on Gilgo Beach versus what we saw out east, so completely different.
Why are the first 3 murder 1? Why are they
5.
murder 1?
Because you have to look at the time, right? So murder 1 under the statute that Mr. Heuermann is charged under, if you have a certain number of murders committed, I believe it's in an 18-month time frame, that constitutes murder 1. All right, so Maureen falls outside that time frame, which is why she's separate than the first 3. Those first 3, in order to prove murder 1, have to be kept together.
Okay. It's an element of the crime, so you have, right, because you have, the element of a murder 1 is 3 alleged murders within that 18-month time frame. So it's an element of the crime, there's really no way to get around that.
Can you say
And
that?
then
I'm sorry.
I know this is like, we're going back to the same thing over and over again, but I'm just counting on my fingers. So you would have the 3 in 1 trial and then 4 individual trials. So you're looking for 5 trials.
Correct.
Okay.
Can you say that about the murder 1? I'm sorry.
The murder 1 statute, in this particular case, is 3 alleged murders within an 18-month period. So it's an element of the crime. It's almost impossible to separate it because it's an element of the crime. You can't take that out of the equation.
So Maureen Brandon Barnes would be a separate case because she was outside the time frame.
She was outside, I believe their allegation is that she was outside of that 18-month period.
It's 24 months, right? 24?
Is it 24? What? Okay. All right, anything else, or we're
Yeah,
good?
just for our producers, can you say and spell your first and last name, just for our producers?
Sure, I'm Danielle, D-A-N-I-E-L-L-E, and the last name is Coysh, C-O-Y-S-H.
Thank you.
Okay, you got it.